Hallo zusammen und willkommen zurück auf Neutrality Studies. Heute wieder
Hello everyone, and welcome back to Neutrality Studies. Today we're once again doing an episode in German, because I'm speaking with two German colleagues, Miss Sarah Luzia, Hassel-Reusing, and Mr. Volker Reusing. Both are human rights activists and defenders who have been advocating for human rights from home for the past 25 years, on a wide range of issues. Today we primarily want to talk about the sanctions imposed by the EU, but also more generally about what people at home can actually do to support human rights. Sarah, Volker, welcome. Thank you for having us. I'm very glad you reached out to me, because you've been in this business for quite a long time, this selfless commitment to human rights. Could you give us a brief overview of the areas you've worked in and how you've been involved in human rights advocacy?
Yes, the whole thing is voluntary. Another important point. Human rights defender is a formal term used by the UN, specifically from Resolution 53/144, in which the member states of the UN General Assembly pledged never to act arbitrarily against people simply because they stand up for human rights. That's also something we would recommend to people like Jacques Both. Anyone who courageously advocates for human rights should at least occasionally mention that resolution in their writings. It also serves as a bit of a deterrent. We and others have had good experiences with that. Of course, it shouldn't be misused, that's clear. As for what we did, one part involved constitutional complaints, and then we engaged in lobbying, meaning we wrote letters to decision makers. We filed complaints with the International Criminal Court, submitted constitutional complaints, and contributed to parallel reports for human rights NGOs to the UN. The constitutional complaints concerned four main issues. One was the Lisbon Treaty. It was about the hierarchy of legal systems, specifically whether it could simply be accepted that EU law stands above everything else. At the time, they wanted to write that into EU law for the first time, which of course violates the hierarchical claims of the constitutional order, the UN Charter, the Universal Declaration of Human Rights, and other peremptory norms of international law. Then there was a provision on the functional privatization of sovereign tasks, meaning that everything not elected should be outsourced to private companies, as we know from neoliberal ideology. Then it should be included that flexible regulations for military operations around the world, in the sense of humanitarian intervention, were created by the think tank Carnegie Endowment for International Peace in 1992 in the study Self-Determination in the New World Order. And that was the first time such an organization was incorporated into primary law. Of course, that has to be limited. That was the reason why we filed the Lisbon complaint. It was about the act of approval for the Lisbon Treaty in Germany. Then came the ESM. There it was essentially about how to deal with a state bankruptcy. Normally, one would think a fair settlement in the debtor country based on the fundamental and human rights applicable there. The ESM envisions something entirely different, modeled after the IMF, cutting social programs and, of course, making a second attempt to push through the privatization of public services. Then we filed a lawsuit concerning the General Data Protection Regulation, directly against the regulation itself, which normally isn't even possible in principle. But the Constitutional Court intervenes when the EU exceeds its powers, and we demonstrated that overreach. We also filed a lawsuit over the Bundeswehr's deployment in Syria because it violates human dignity and the constitutional commitment to peace, and because it again involves overstepping of authority, also with regard to the fundamental right to vote. On that point, we were largely vindicated in what we had argued in the Lisbon ruling. However, they smuggled the answer into the Lisbon ruling, which was formally a decision on the lawsuits filed by Dr. Gauweiler and by the Left Party, both of which were legitimate cases. We were allowed to contribute to parallel reports in an association for intersex people. The issue there was always the human right to health. Informed consent is part of that. The patient decides for themselves after being properly informed, and not the parents, if it's not an emergency, when a person's physical sex is not clearly male or female. Can't we just wait and ask the person themselves whether they want a corrective surgery? In fact, we must, because otherwise it would be a violation of physical integrity and health. And we were heavily involved in the parallel report for the ZV, which dealt with the COVID measures in Germany. But of course, the global perspective was always kept in mind as well, to show the scale of the human rights violations taking place, from work affected by lockdowns to health, especially for all those whose health was destroyed by the measures, shocks, and everything that came with them. And the letters we wrote to decision-makers concerned, among other things, granting the WHO authority over the international health regulations. There were also plans to give it authority over climate issues. The idea was to introduce climate lockdowns and to force everyone over 60, as well as all those working in healthcare, to get COVID vaccinations. And if, according to the best global estimate available, based on excess mortality correlations from 125 countries by Professor Dr. Denise Rancourt, there were 16.9 million deaths in 2021 and 2022, roughly as many as in World War I, but twice as fast. One can imagine what kind of collapse of healthcare systems worldwide would have occurred if those authorizations had gone through. And the majority of states kept a poker face. On June 1st, 2024, they formally adopted the international health regulations, but beforehand they threw out everything that was truly dangerous. That's why many COVID critics are still spreading panic, because they haven't read that all the dangerous parts were removed. That gives you a bit of insight into what we've been doing so far, for the past 25 years.
Lieber Volker, du redest wie ein D-Zug, aber
Dear Volker, you talk like an express train, but as they say in English, in a nutshell, meaning summarized or briefly put. You've been working for 25 years now with various tools to make your voices heard, either through reports you co-author or through lawsuits. These lawsuits, well, do you have to be a lawyer for that? Is either of you a lawyer? How do you go about just taking the state to court?
For constitutional complaints, you don't need any professional qualifications for written proceedings. But in oral hearings, you must either have a lawyer, a law professor, or a special permit. We've never actually made it to an oral hearing, since the Constitutional Court, except in the Lisbon case, has always avoided doing the work. Each time, it has merely sent signals about how things should really go. And in the Lisbon ruling, they did decide in our favor, at least to a significant extent, that the inviolable parts of the basic law are the highest law in Germany, not the EU treaties. Unfortunately, they didn't mention the prohibition on wars of aggression, but in every other way they could think of, they used the basic law to set limits on the vague EU legal provisions concerning war. And they explicitly emphasized the state's monopoly on the use of force, thereby blocking the outsourcing of public service functions to private entities, such as special military courts and everything not directly elected. And that created a psychological effect that led to a significant slowdown of this sellout of sovereign functions in other member states as well. Wait, what was I going to say? But it didn't show up in the legal commentaries, because they had slipped it in under someone else's name, since it wasn't part of that person's lawsuit. And what we also did was file criminal complaints, one concerning Greece, for having forced them to cut their healthcare system to the bone. And with the Troika, even though the UN says, text number 32, General Comment number 14 on the human right to health, when a state goes bankrupt, health should be the last thing to cut, not the first. And many people suffered health damage back then. Some even died. it didn't lead to legal proceedings at the time because we didn't get enough testimonies from severely affected individuals to achieve that, to prove the large-scale impact. And regarding COVID, at least the measures were scaled back worldwide. The International Criminal Court again acted as a deterrent, but this time on a global scale. That means in terms of prevention and containment, though not yet the initiation of criminal proceedings, we already have a global effect. As for the education around COVID, it's not just the two of us. We're already getting support from other people, but the two of us are the ones putting ourselves out there.
Ihr zeigt Gesicht und ihr schreibt diese
You show your faces, you write these papers and statements, you go to court and file lawsuits. I think it's important to know that any citizen can do that. And being a human rights defender is a general term for people who stand up for human rights. Now, if we bring this to the topic of sanctions, these EU sanctions against individuals, but also against organizations, what can you tell us about that? Where does one start to understand what this is about? And what can be done to defend the human rights of people like Jacques Bode, Nathalie Jamp, and Hüseyin Doğru?
Nathalie Jamp, Hüseyin Doğru zu verteidigen.
Da würde ich gerne einmal stichwortartig sagen.
I'd like to briefly outline the approaches we see and then zoom in more closely. So, first, expose the ideology behind it. Then, it's important to take legal action against it, within the framework of EU law, since it's being imposed in the EU legal context. Next, make use of universal human rights, keyword UN Special Rapporteurs, to make things visible worldwide and call them out. Then there's the question of whether, also at the UN level, an ICJ advisory opinion should be sought, specifically on how to define the human rights boundaries to ensure that the EU treaty doesn't become invalid because of these regulations and amendments. Can you spell that out? So, the ICJ, that's the International Criminal Court? No, that's the International Court of Justice.
Nein, das ist der Internationale Gerichtshof. Und
And at the International Criminal Court, the question arises whether it constitutes a crime against humanity. And yes, I would like to start with the ideology. There is this ideology of hybrid threats, and in 2017 a think tank was established. Formally, it is a private law organization. EU and NATO member states are involved, naturally with the support of EU and NATO institutions. The goal is to combat Russian narratives and Russian propaganda. And then the question arises of how far one is willing to go. The model for this are the persecution lists in Ukraine. There are various organizations there. Some in Ukraine go so far as to say that people should be killed. They themselves do not go that far. Definitely not.
Eindeutig nicht.
The reactions of the EU, or this think tank, don't go so far as to suggest that internal enemies should be physically eliminated.
Genau, ganz eindeutig nicht. Aber wie weit sie gehen, da haben wir
Definitely not. But how far they go, we found a paper they published in January 2024. It's called, just a moment, How Ukraine Fights Russian Disinformation, Beehive versus Mammoth. So how Ukraine combats Russian disinformation, Beehive versus Mammoth. And in it they have various lessons, that's what they call the chapters. In lesson 6, they say that of course they want to discredit the people who spread this propaganda, but also that those people should be financially ruined, meaning they lose their jobs, their companies lose customers, and they should also be criminalized by creating special criminal laws to make that happen. And now we see, people are being accused of spreading terrible Russian propaganda.
Dass sie ganz schlimme russische Propaganda machen würden. Ein Jacques Bode äußert sich ja relativ ausgewogen.
A jackboot expresses himself in a relatively balanced way. Still, he's accused of wrongdoing, and then sanctions are imposed that go deeper than ordinary criminal law interventions, without a corresponding lengthy procedure, like in criminal law, with the necessary procedural safeguards ensuring he'd have a proper chance to speak beforehand. So, in effect, it's something like a substitute criminal law, and something that can even cause people to starve. And that violates a whole range of human rights, especially the prohibition against depriving people of their legal standing, what used to be called civil death. In Old Prussia, that's what they called it, or prescription, or outlawing. Think of Martin Luther. That's prohibited under Article 6 of the Universal Declaration of Human Rights.
Verboten in Artikel 6 der Allgemeinen Erklärung der Menschenrechte. Die Allgemeine Erklärung für Menschenrechte ist verbindlich für
The Universal Declaration of Human Rights is binding for everyone who joins the UN, because you can't become a member unless you sign it. And that's the concrete implementation of Article 1, Section 3 of the UN Charter, the Universal Declaration of Human Rights. It's also included in Article 16 of the UN Covenant on Civil and Political Rights. So that's already a violation. Then there are all the fundamental human rights that procedurally guarantee that one must be heard and have access to legal recourse. And of course, it also violates the human right to food and housing when people can no longer afford these things. But essentially, this right is enshrined in the UN for all states, that no one may be made an outlaw. And that's exactly what they're doing here.
Sorry, it's fine. I'll come if it's necessary.
Yes, and I'd like to say something about the hierarchy of the legal order, which is very important. Many people, especially those who usually work with EU law, claim that EU law stands above all other law for all EU member states. But that's only true from the perspective of EU law. And it's important to understand this when I later talk about the issue of nullity. How one can use UN law and the Vienna Convention on the Law of Treaties to put pressure on the EU to limit the entire sanction system in terms of human rights so that it no longer violates human rights. In other words, so that it's, let's say, no more dangerous than ordinary criminal law, apart from the fact that the threshold for intervention is low, but no longer leads to people being left completely without legal protection. So from the UN's perspective, it's relatively straightforward, and what is completely undisputed, constitutional orders take precedence over ordinary laws at the national level. Of course, since they also encompass the legislature, and all international law takes precedence over ordinary laws. See Article 27 of the Vienna Convention on the Law of Treaties. National laws are no excuse for failing to implement international obligations. But then there's the relationship between international law and constitutional order. Before 1964, that was quite clear. We had the UN Charter, which states that nations are sovereign. That only works if the UN, along with its charter, is subordinate to the constitutional order of the member states. And then the UN Charter says in Article 103, I, the UN Charter, am the highest international treaty. And then we have the Universal Declaration of Human Rights, which says that every person has a right, in its Article 28. And it is binding because it was adopted as an annex 3 years after the UN Charter to give life to Article 1, Paragraph 3. So which human rights are those that belong to the human rights objective? Article 28 states that everyone has the right to a social and international order in which the rights and freedoms set forth can be fully realized. That means other international law has to adapt to it. And Article 29, Paragraph 3, states that the UN's human rights may not be misused against the UN Charter. What's the logic? World peace is even more important. Peace itself is even more important than human rights. No war in the name of human rights. That's the logic behind it. And there's an advisory opinion from the ICJ dated July 8, 1996. At that time, they dealt with the question of whether nuclear deterrence is permissible, yes, and whether nuclear weapons may be used. They couldn't agree on that. Maybe a devastating effect was meant, maybe not. And then they had to determine which law holds such a high rank that it can serve as the standard for this. And they said, in addition to the UN Charter, the UN human rights, international criminal law, as well as the Geneva and Hague Conventions of Humanitarian Law of War, definitely belong to this category. That is, the rights civilians and non-combatants have in wartime. And the Hague Conventions, meaning the limited human rights protections for soldiers, also hold a correspondingly high rank. Hence, once again, the confirmation of Article 28 AMR with this high status. And thus, from the UN's perspective, all other international law is practically ranked below that.
Aus Sicht der UNO darunter. Und jetzt kommt die EU.
And now comes the EU. In 1964, in the case of Costa v Enel, the ECJ decided, without any legal basis and without having the authority to decide, that the entire European community could basically be forgotten if EC law didn't take precedence over all national law. At first, this applied only to the EC treaty, not the EU treaty, meaning that the former would take precedence. And people cheered, even though the EU had no legal basis for it at all. Pure arbitrariness. Then in 2009 came the Lisbon Treaty. It renamed the EC Treaty and the EU Treaty, and in Articles 1 and 51 and Declaration 17 in the Annex, those are the legal bases, established that from the perspective of EU law, it now actually stands above the constitutional order of the member states.
Über der verfassungsmäßigen Ordnung der Mitgliedstaaten steht.
May I briefly jump in? What you're explaining here is very, very important and essential. These different areas of law, the question every court has to clarify is whether it has jurisdiction and which area of law takes precedence. And what you described with the UN Charter is absolutely correct. So, if we imagine international law as a pyramid, the UN Charter stands at the very top, and below it comes human rights. Many people don't even know this. Human rights have only existed since 1945 to 1948. Before that, international law was simply the law between states. Since 1945, over the past 80 years, we've continued to spell out that international law also applies to individuals, that individuals can assert their rights under international law as human rights. And that's absolutely essential, what you're saying here. And yes, the EU is simply making a claim to power here, saying that our law, EU law, takes precedence over the constitutional law of the member states. But what you're pointing out now is, oh, but that conflicts with the Charter. And it does conflict.
It also conflicts with certain constitutional orders. The Polish constitution clearly states that it is the highest law in Poland, and the German Basic Law was adjusted to this legal issue in the 1990s. Costa v Enel, the continuous case law of the ECJ, without a legal basis. And now, as stated, somewhat complicatedly, in Article 23, the treaties of the EU, meaning only the fundamental treaties, not directives and regulations, etc. And in this sense, the Lisbon ruling decided, and our complaint only raised the question of hierarchy. 2 BVR 1958-8, in Headnote 4, it states that they protect the constitutional identity. And here they said that this includes the fundamental rights and the structural principles, meaning everything that is directly or indirectly protected by the Eternity Clause, Article 79, Paragraph 3. In paragraphs 217 and 218, they went into a bit more detail. They also said, it sounds a bit complicated in Headnote 3, that there must be enough room for universal human rights when implementing EU law. They didn't really address the question of hierarchy there. They just said there must be enough room for it. And they said that the EU's foreign and security policy must remain at the level of ordinary international law, meaning below the UN Charter, so that no one can sidestep the prohibition on wars of aggression, but they didn't explain that in detail. And they also confirmed the existence of the peace mandate in Article 1, Paragraph 2, but not how far it extends or what it includes. And we had argued that this would be a fifth, previously undiscovered structural principle. We said, no, that's not a structural principle. It's practically on the second level, together with the constitutional mandate for European integration. That is the basic requirement to be an EU member, from Article 23 of the Basic Law. And then comes EU primary law.
Und dann kommt das EU-Primärrecht.
But with one difference. Where does it say that the peace mandate is anchored in the eternity clause?
Also voll unantastbar ist.
So it's completely inviolable. So it does carry a bit more weight, though not quite as much as fundamental rights and structural principles. It goes far beyond a mere prohibition of wars of aggression. But you only arrive at that through the historical interpretation by the Parliamentary Council and the Stuttgart speech of hope that inspired it.
Was das inspiriert hat.
Let's go back to the question of sanctions. Because what you've just explained here is that the issue is by no means settled, and that you can even demonstrate in court that there is indeed room to argue. No. By the way, the law of the member states can, under certain circumstances, actually override EU law. How in what way do you think that's relevant now to the question of how people like Jean-Claude?
We asked a question here. You had asked whether Switzerland could do something, such as through a popular initiative. Yes, it can. So a referendum could be held to determine whether this provision in EU law, Article 215 of the EU Treaty, is invalid. Specifically, by instructing the Swiss federal government to submit a request to the UN General Assembly to commission an expert opinion to determine whether it is invalid or needs to be limited.
Feststellung, ob das nichtig ist oder ob es eingegrenzt werden muss.
Ich würde gerne erläutern, die Nichtigkeit.
I'd like to explain. Nullity applies to the entire treaty. And if the EU treaty were null and void, the EU would be largely incapable of acting. That would create enormous pressure, if only through public debate. For the Swiss government to actually implement it effectively, the text of the referendum would, of course, have to specify exactly how the question for the advisory opinion should be phrased and which specific universal human rights are to be named. That is, how strongly they must be protected in order to avoid the consequence of nullity. The provision that can lead to the nullity of entire treaties if they are incompatible with peremptory norms of international law, and that includes the UN's human rights, is Article 53 of the Vienna Convention on the Law of Treaties. To obtain an ICJ advisory opinion, a majority in the General Assembly is required. A single state or government can submit the request there. That would create maximum pressure to limit it in terms of human rights. However, it's a slow process. Measures are also needed to help those affected quickly.
Let me say again, sorry, I lost my train of thought. Spell out the whole idea again. So the Swiss people could, through a popular initiative, demand, if it passes, which in itself is already a 4 or 5 year process, but they could say, okay, the Swiss government must now submit a request to the UN General Assembly that would then do what? Say that again.
Ja, dass die Vollversammlung abstimmt.
Yes, that the General Assembly votes to instruct the UN International Court of Justice to issue an advisory opinion. How exactly these EU sanctions must be limited in order not to violate certain universal human rights. For example, that no one may be declared an outlaw, Article 6 of the Universal Declaration of Human Rights, or the human right to food, to health, to housing, to everything that is being violated there, in order to ensure that no nullity of the EU treaty could arise under Article 53 of the Vienna Convention on the Law of Treaties, due to the fact that Article 215 of the EU treaty is incompatible with it.
Und es gibt da 5 Auslegungsprinzipien und die
And there are 5 principles of interpretation, and the actual application of these sanction provisions from Article 215 of the EU Treaty takes place with a very serious violation of these UN human rights. The text itself doesn't say that, and there is room for interpretation to narrow it down. And the ICJ itself, I believe in a 1957 ruling that dealt with indigenous territory, stated that a mandatory requirement for a human rights compliant, or just cogence compliant limitation, always takes precedence over a declaration of nullity.
Immer vorgeht vor der Nichtigkeitsfeststellung. Wir wollen die EU nicht lahmlegen.
We don't want to paralyze the EU, but we do want to create enormous pressure so that it is compelled, airtight in terms of human rights, at least according to UN human rights standards, to limit the use of sanctions and make them more humane, including, of course, the guarantee of legal recourse. That would significantly diffuse the situation, and even the public debate alone would push the EU to show restraint. We've already seen this happen in other cases where we helped to spark such discussions to some extent.
Geholfen haben, ein Stück weit anzustoßen.
Ich muss hier ganz kurz beifügen. Also
Ganz, ganz wichtig.
I have to add something very briefly that's really, really important. There would definitely be a majority in the UN General Assembly in favor of it, because many countries are also affected by these sanctions, and that would send a huge signal.
Und das würde ein Riesenzeichen setzen.
Und es gibt viele Staaten, die
And there are many countries suffering under the loan conditions imposed by the IMF and the World Bank, which are so severe. And if sanction limits are set, the IMF and the World Bank will see the next logical step as a legal boundary. That's why a majority will want that. A government needs to have the courage to do it.
eine Regierung den Mut haben.
Und der Punkt ist also,
And the point is, there's the group called the Friends of the UN Charter. That's the group most affected by these sanctions. It doesn't matter whether it's the US or Europe. They're the ones hit the hardest. So they would be natural allies. And all the developing countries, meaning the Global South, are certainly interested in this as well.
ist da mit Sicherheit auch dran interessiert.
Genau, ich muss hier einfach ganz kurz noch anfügen für die Leute, die
I just need to briefly add something here. For those who aren't aware of how the human rights apparatus actually works. To a large extent, it's not about saying human rights always win. It's about taking legal action. It's about demanding them. It's about generating political pressure through human rights discourse and human rights claims before these courts. And what you're saying here, and I think it's very good, is a highly creative idea for generating pressure. It's not just EU sanctions that are on the table. There are also US sanctions, for example, against people like Francesca Albanese, or against members of the International Criminal Court, which in a very similar way restrict the human rights of those individuals. So the question now is, how could we creatively generate pressure through the UN General Assembly? Because that body is not under US control.
ist nicht unter der Kontrolle der USA.
It's enough for any state to want it. For an expert opinion, that state doesn't have to be directly affected. It doesn't have to be Switzerland. It doesn't have to be Belgium. It can be any country in the world whose government is brave enough.
Also nehmen wir an, ich frage...
So let's assume I ask our good colleague, Mr. Evarist Bartolo, the former foreign minister of Malta, whether there wouldn't be enough people in Malta, whether the Maltese government would be willing to submit such an application.
Da ist die Frage...
That's the question. That's the question. So, whether that's too much for them, because the EU treaty could actually become void, that means the entire EU would, if that happened, lose all its mechanisms. They would have to create an entirely new treaty. They would be incapable of taking action. And whether a state that's part of the EU would actually do that.
Das macht...
Of course, that's not likely. I just wanted to clarify the principle briefly. So in principle, Iran could also submit such a request. The point was really just to ask the International Court of Justice to issue an opinion on which jurisdiction takes precedence and whether the EU's claim is correct.
But for that, the question of hierarchy wouldn't even need to be settled. From the UN's perspective, EU law is ordinary international law and has to fit within that framework. The UN just doesn't say that too loudly, since its member states are also good financial contributors, and so on. And of course, one doesn't seek confrontation unnecessarily. I also wanted to say something else about the UN's human rights system. There are special rapporteurs on human rights, who are usually assigned to specific topics. And there is also a special rapporteur on unilateral measures, see for example the United States, and on sanctions. These special rapporteurs can also issue statements on topics at short notice.
Die können auch kurzfristig zu Themen Stellung nehmen. Man muss ihnen nur die hinreichende Tragweite zeigen.
You just have to show them the full scope, from the signal effect to the people who are particularly affected. So Jacques Both is someone for whom this would be an excellent fit, ideally along with one or two others. And the likelihood that they will comment on it, which would have a strong diplomatic and psychological impact, even if not a legal one, is actually not that small. It's best to contact several special rapporteurs, including those for food, housing, and everything that concerns particularly sensitive rights. But this one is crucial because it's her area of focus.
How do you do that? If you were speaking to Jacques Both right now, dear Jacques, do the following.
Well, then I'd say he should identify which universal human rights he believes are affected, from freedom of movement, to the right to be recognized as a legal person, to the guarantee of legal recourse, to the protection of property, which is also included in the Universal Declaration of Human Rights, as well as the rights to food and housing. And he should present this accordingly and ask the special rapporteurs, ideally several of them, to publicly comment on it, in order to further increase the chances of success, emphasizing that sanctions must be restricted to be 100% compliant with human rights. That alone would already have a significant impact on public awareness.
Das würde schon mal einen erheblichen Einfluss haben, öffentlichen Bewusstsein. Die Sonderberichterstatter haben wir schon erlebt.
We've already seen the special rapporteurs in action. They've spoken out on various issues, whether it was police violence against the Yellow Vests or the austerity measures of the Troika. And during the coronavirus crisis, they also made statements, even though at first they were in shock themselves and not fully informed. So they've spoken out on many topics and done what they could to encourage moderation. It's something that helps quickly, brings some relief, but doesn't yet solve the problem.
Eine Linderung verschafft, aber das Problem noch nicht löst.
Those are actually two different ideas now, right? Udo's one, General Assembly, request for expert opinions.
One is the tougher method, and here we already have a diplomatic one.
Und was natürlich unbedingt erforderlich
What is, of course, absolutely necessary is to respond within the framework of EU law. In that context, we read a scholarly book, also prompted by the debate in neutrality studies, by Dr. Julia Bartman from 2011, The Cross-Terrorist Sanctions Regime for Combating the Financing of Terrorism. In it, she provided an overview of the case law up to 2011. At that time, the legal process always began with the EU Court of First Instance, followed by the European Court of Justice. In the Kadi case, among others, it emerged that they did not yet have to provide detailed justification when imposing sanctions, but they did have to do so during the court proceedings, where they had to demonstrate the legitimacy of their actions.
But
a normal human rights and fundamental rights review doesn't just ask whether there's a legitimate purpose that allows interference with human or fundamental rights at all. It also has to be necessary, meaning that milder measures wouldn't suffice. It must be just a moment. It must be required. It must be appropriate. It must not interfere too deeply, meaning it must not affect the essence of fundamental or human rights. And it must also be proportionate, meaning the goal must be important enough to justify such a deep interference. And here, when it comes to Russian narratives or alleged Russian narratives, something very simple would suffice. Namely, issuing a particularly visible counterstatement. That we have fact-checkers. They exist, and they're sufficient. And this isn't about terrorism, where there's an urgent need for action, or about suspected terrorism, where people's funds need to be frozen, but about something that poses no immediate danger at all. They should have simply said about Jacques Bode, he's being very critical, so we'll assign taxpayer-funded fact-checkers to review his statements, And whenever he says something unwelcome, our fact-checker will post something in response, making sure it's just as visible, or even more visible, than Jacques Baud himself. There would have been no need to sanction him at all.
Den hätte man gar nicht sanktionieren müssen.
Ja,
Das hätte vollkommen.
That would have been completely. But we actually fear that this message is about something entirely different. Namely, it's about, similar to what happens with people at the International Criminal Court, trying to bring these people into line deliberately and with an external signal to others, in other words, an interference in the actions of UN staff.
In das Handeln also von UNO-Mitarbeitern.
These people are being intimidated in order to intimidate other UN employees as well. Just as throughout the entire sanctions regime and within the hybrid CEE ideology, a limited number of people are intimidated to scare off a larger group who might take up Russian arguments. What makes the Barbo case special is that it could also have an intimidating effect on the UN itself.
Ja, das ist sehr gut und sehr wichtig. Also
Yes, that's very good and very important. So, a fundamental problem we have is that these sanctions are a political tool used to act against people who are considered undesirable. And then there are various things that these sanctions bring about, the function of the sanctions, so to speak. One is, of course, to restrict these people to fulfill the pretext. Another is to deter others, and so on. Third, it's also a way for the EU to once again demonstrate sovereignty. I, the EU, am capable of defining the internal enemy, and to do so in a way that is technically lawful, in the sense that there are various parts of EU law that grant the executive, meaning the EU Council, the authority to do this, but they bypass the legal process that should actually be available to individuals.
Der eigentlich den Individuen offen stehen sollte. Also das ist das ganze Problem dabei. Jetzt eben die Frage.
So, that's the whole problem. Now the question is, how do you deal with it? Some people say it can only be addressed politically. But if I understand both of you correctly, you're saying no, it's definitely possible to use the existing legal and human rights institutions to apply pressure to get the EU to back down, which is actually a political approach.
Bringen, hier einzulenken, was eigentlich ein politisches Vorgehen ist.
Yes, so filing a lawsuit there through the EU legal process is definitely necessary. And what's crucial is, what is the highest law within EU law? It's not all on the same level. Article 1 of the EU Treaty, Article 51 of the EU Treaty, Declaration 17 in the annexes, and Article 6 of the EU Treaty. The highest law consists of the EU Treaty, the TFEU, the EU Charter of Fundamental Rights, and all the protocols and declarations in the annexes to the EU Treaty and the TFEU. So the EU Charter of Fundamental Rights naturally takes precedence over all EU directives and regulations, and everything done on the basis of Article 215 TFEU must, from the perspective of EU legal logic, also comply with what the EU Charter of Fundamental Rights allows.
Was die EU-Grundrechte erlauben. Die sind zwar zum Teil etwas lückenhaft, insbesondere die
They are somewhat incomplete in parts, especially the social ones, but they do include rights such as human dignity, life, physical integrity, freedom of expression, freedom of occupation, entrepreneurial freedom, prohibition of discrimination, social security, healthcare, access to public services, presumption of innocence, and prohibition of retroactive criminal law. And in addition to the EU fundamental rights, the EU Treaty also contains the economic fundamental freedoms, and the free movement of capital is under heavy attack. And the presumption of innocence, why that one?
Die Unschuldsvermutung, warum die? Es geht ja hier nicht Strafrecht, ja.
This isn't about criminal law, right? But they're interfering more severely than criminal law ever could, more than any criminal statute would allow for making propaganda for someone. Even if someone committed incitement to hatred, they might go to prison for a few years, but they wouldn't be completely cut off from all means of survival, left to starve. So this is worse than anything that exists in criminal law when it comes to propaganda. And therefore, it's also a prohibition on circumventing retroactive criminal law.
Der Umgehung rückwirkenden Strafrechts auch. Und dieses Verbot
And this prohibition of retroactive criminal law exists in many constitutional systems. We have it in the Universal Declaration of Human Rights and also in EU law. And we see an opportunity in the EU legal route. But you really have to assert all the rights involved to put significant weight on the scales. And this textbook we read in 2011 deals with the financing of terrorism. But here, it's only about unpopular expressions of opinion, not terrorism. So the EU fundamental rights must be given much more consideration. It's extremely important to me that no one misses any deadlines. We don't know the filing deadlines. We haven't looked them up. That's something to watch out for. So, what helps quickly enough? Taking the legal route under EU law, plus involving the UN's Special Rapporteur, where, of course, the standard is the UN's human rights framework. And as an ultimate measure within the EU, setting boundaries, even if it's a slow process, and you need at least one government brave enough to do it. Then the question arises of how to define the limits so that the risk of nullity for the EU Act is reduced to zero. We're also seeing issues of international criminal law here. That would be the International Criminal Court. But that would require bringing a whole series of cases involving severely affected individuals. That, again, takes some time. I'd be happy to explain that. The question is whether it constitutes a crime against humanity, given the systematic nature of the actions and how deeply, or rather impermissibly deeply, the interference goes.
Maybe we shouldn't go too much into detail, because my question now is more about how to put this into practice. I'd like to draw on your experience a bit. How should this be done now? But long story short, there are indeed different paths, possibly including the criminal court. Although, maybe we should leave that aside for now, since that institution is currently a bit shaky.
Nein, das tut nicht. Das sind eine begrenzte Zahl von Staaten
No,
ausgetreten.
he doesn't. Only a limited number of states have withdrawn. Others are expressing discontent. And if you look at the example of Gaza, when many governments want something to be prosecuted, they show courage and even accept that the United States might take unilateral measures against them, so-called sanctions. The International Criminal Court is firmly established, and the majority of countries, except in Asia, where it has only a few members, stand behind it. So that's not true. The question of crimes against humanity is at issue here, an unlawfully deep interference, essentially, with human rights. That's what constitutes persecution. When people become seriously ill, that too is a kind of crime against humanity, and when people die as well. And if that causes corresponding psychological suffering, this rendering of people helpless, it can also be psychological torture. Only, you'd have to prove that it's being done on a large scale, and it's not as if masses of people are being sanctioned. I don't really see that, or else that it's systematic. And here, a limited number of people are affected, but with enormous impact. It has tremendous symbolic power. A limited number of people are treated as if they had no rights, and that frightens a much larger number of people. And of course, there's the question of subjective intent. Do they just wave these sanctions through? After all, it's decided in the Council of Ministers. Who drafts this? So, are they really unaware that this could be a crime against humanity? Well, when it comes to the subjective element of the offense, I'd put a question mark there. But how much awareness does it actually take? You don't have to know that it's a criminal act. If you know that, in the ordinary course of events, it has such severe consequences, produces systematic effects, and affects a certain number of people so that the systematic nature is at least fulfilled, then the question of a crime against humanity arises. But you'd have to gather cases for that, and only those people who are really hit hard would count. Someone living outside the EU without an EU bank account wouldn't be affected as severely as a Jacques Bro, who probably has his bank account in Belgium, lives there, and can't get out.
und in Belgien lebt und da nicht rauskommt.
Oder ist es nicht Dogo, der als deutscher Staatsbürger.
Or isn't it Dogru, who, as a German citizen in Germany, is now really in a bad situation because it also depends on how Germany itself wants to interpret the implementation of the sanctions? But tell me this. How would one proceed now, concretely? If you were advising Jacopo or Hussein Dogru, what 3 or 4 measures would you say need to be implemented now, and where should one start?
Würdet ihr sagen, muss man jetzt umsetzen und wo fängt man an?
Ja, erstmal anfangen bei allem, was
Yes,
schnell
first, start with everything that can be done quickly. Within the EU legal framework, pay attention to deadlines. Make it very clear, of course. This is not about financing terrorism, but about an unpopular opinion. You shouldn't intervene that deeply at all, and you should bring up all the EU fundamental rights that exist and could apply to him.
alle in die Waagschale werfen. Und das
Would you call a lawyer, or do you need 2 or 3 lawyers? How do you structure it so you don't drown in all the work?
Dass man vor lauter Arbeit nicht ertrinkt.
ja, das eine ist ja am Fristen zu wahren, dass man EU-rechtlich
Yes, one part is to meet the deadlines, to set limits within the EU legal framework. We've already mentioned the key arguments. This is only about unpopular opinions, not about financing terrorism. You can handle all that with counterstatements, with fact-checkers. Then he'll just have fact-checkers for years, and every time he publishes something, the fact-checker says they see it differently, and everyone deals with it. And the other part is, a special rapporteur moves quickly. That reaches a lot of public opinion, decision-makers, diplomats, and then to make calls to gather whether there are enough cases to show the pattern, that people are being targeted.
dass da Leute fertig gemacht werden, gerade beim Verfolgungstatbestand, bei Verbrechen,
Especially when it comes to the offense of crimes against humanity, it has to be comparably serious to other areas under the jurisdiction of the criminal court. But I do see a certain comparability there, that it's a kind of apartheid-like exclusion, and therefore the element of severity might also be met. The real issue would rather be finding enough cases of people who say, yes, I want my case to go before the criminal court. 2 or 3 wouldn't be enough, even if it's about systematic patterns rather than large-scale actions. You'd need to present a few more. And if you provide statistics on how many are sanctioned, you'd need correspondingly fewer individual cases.
wie viele sanktioniert werden, muss man wieder weniger Fälle bringen. Aber das hat eine gewisse Vorlaufzeit. Aber
But that takes some lead time, and it has a huge psychological impact. However, the International Criminal Court is known for taking a long time to do its work. The admissibility is always challenged, whether the national legal process should be exhausted first, and so on. You have to demonstrate that only the criminal court can act here. National prosecution authorities either cannot because of immunities, or it would be futile. Or the matter is so international that the court has to take it on, because any national authority could only handle part of it. That would also have to be justified accordingly. But the number of cases would still be manageable.
Aber es wäre noch überschaubar, die Zahl der Fälle. Und wie schnell das geht, einen Antrag zu stellen.
And how quickly it can be done to file a case with the ICJ. It depends on where there's a courageous government. And it's not about making the EU incapable of acting. It's about defining it comprehensively based on all the human rights affected under the UN, so that what's being done to people there doesn't work in practice. Yes, everything must be proportionate, of course also in relation to what's being done. Ultimately, the goal should be that people don't think the UN's opinion should assign them a fact-checker, whether they want one or not. And well, I think that should be the goal.
Das, denke ich, sollte das Ziel sein.
Also wenn ich euch richtig verstehe, dann empfehlt ihr...
So, if I understand you correctly, you're recommending a 3-part strategy, right? So, building it on 3 pillars. On the one hand, by calling on the special rapporteurs. On the other, by presenting these cases as a kind of collective complaint. And third, by taking a political route. So that's how you try to structure it.
Einen politischen Weg. Also so würdet ihr versuchen, das zu strukturieren.
Das sind
These are individual lawsuits filed by affected parties within the EU's legal framework. Before a criminal court, one can only file criminal charges, not lawsuits. There is no position as a plaintiff there. It's about the international community's right to prosecute particularly serious crimes. And that process tends to move rather slowly. What is effective more quickly, and where one must be careful not to miss any deadlines, is within the EU's legal framework. These are the special reports meant to send signals quickly, to call for criminal reports swiftly. The other part depends on when enough cases are gathered to file a criminal charge. And then there's the question of nullity, or an ICJ advisory opinion. When will there be a government brave enough to raise that question? That can also be done diplomatically, with the idea that this is the occasion. We mean no harm to the EU, but the EU also needs to be restrained so that its sanctions remain within a humane framework.
Innerhalb eines menschlichen Rahmens bleibt mit ihren Sanktionen.
It's simply important to be aware of this, because, depending on whom you ask, you'll also hear the opinion that those affected by the sanctions can defend themselves within the EU framework.
But you say that's not true. The fastest would very likely be Switzerland.
Ja, mit der Volksabstimmung, auch wenn die lange braucht.
With the referendum, even though that takes a long time. No, it really takes a very long time. And in Switzerland, there's also the peculiarity that popular initiatives ultimately lead to a constitutional amendment. So, it would be written into the Swiss constitution that this motion must be submitted to the UN General Assembly. Therefore, no, it would be a very drastic way to achieve that, but it's good to be aware of what could be done if one has enough drive. Is there anything else regarding these sanctions that we haven't specifically discussed yet? Something you think still belongs on the table?
Gibt es noch etwas, was wir jetzt in Bezug zu diesen Sanktionen konkret noch nicht besprochen haben, was ihr denkt, was noch aufs Tapet gehört?
Ich denke, wichtig ist die Öffentlichkeitsarbeit.
I think public outreach is important, showing which rights are being violated. And you don't have to wait for the special rapporteurs to do that. There are also plenty of alternative media outlets. And it's important that we don't approach this from a moral standpoint. We're no longer in the 19th century. We now have a wide range of human rights. And really, when you know your rights, that carries much more weight. The arguments you make, how you're affected. And if Jacques Path and the people advocating for him also mention these human rights. In the email we sent, we also wrote which human rights we believe are being violated. And it would be great if Jacques Path and other affected individuals looked at these arguments and incorporated them into the reasoning they pass on to lawyers. That means, for public relations, it's really important to mention the specific articles and the names of the rights. That simply gives the factual arguments more weight. We're seeing a lot of positive examples of this, and it's not about perfectly reaching every average person. People are allowed to grow beyond themselves. It's not a bad thing if they learn that too. After all, those rights do exist.
Nicht schlimm, wenn die das auch lernen. Ach, die Rechte gibt's auch, und dann nehmen die sich auch mal ein Buch in die Hand oder gucken im Internet.
And then they might pick up a book or look online to find out what rights they have. And if that becomes part of our general culture, if someone wants to assert something in their favor and says, look, these are the rights I see on my side, then everyone treats each other more carefully and appropriately. We shouldn't underestimate the general public's ability to learn. The point is to challenge them intellectually a bit, and that's why this should be part of the argumentation. Every press release, everything that's said about how they're doing, always include it. Which rights are seen as being violated? That's absolutely crucial, and it has a huge multiplier effect. That many people who previously thought they couldn't do anything surpass themselves because they know they have these rights. That's also very important for public outreach in advance. It increases public pressure when legal action is taken later. But it's important not to miss any deadlines within the EU legal framework and to reach out to the special rapporteurs, put everything into public communication so that you can also keep control of the timing yourself.
Das Timing unter Kontrolle hat.
Und man sollte nicht unterschätzen.
And one shouldn't underestimate that staging such a referendum will by itself stir up a lot of emotions across Europe.
Emotionen aufwirbeln wird in Europa.
Ja. Nein, also wir haben, nur zu allen bei den Informationen.
We had a case where basically one individual said they wanted to have the dehorning of cows banned because it violates animal rights or harms the cows. And he almost got away with it. It was almost accepted. The vote was close, 52 or 53 to 47 or 48. So in Switzerland, you can actually bring even rather unusual proposals directly to the people if you put enough effort into it. I don't want to downplay that at all. It's a legitimate path that exists.
Das ist ein Weg, den es gibt. Ich möchte nur für die Leute vor allem, die im Moment in
I just want to say this for the people in our circles who are becoming increasingly pessimistic and saying, international law doesn't matter anymore. Everything's gone anyway. Genocide in Gaza and so on. One simply has to say, yes, genocide in Gaza, and yes, international law is failing. But there are also moments when it works. The history of human rights is the history of asserting those rights and pushing forward the legal claim. And this pushing forward is anything but dead. Just to say, this time we're having a hopeful discussion about what can be done.
Ja, was ganz wichtig ist,
Yes, what's really important is who decides whether something becomes invalid, and so on. There's this concept of jus cogens, meaning peremptory norms of international law. It develops in written form, through treaties, but it always depends on a large majority, ideally even a consensus among all states and governments, agreeing that it's valid and binding. For example, the privileges of diplomats. Today there's a convention about that, but before it was unwritten, not part of an international treaty. And yet everyone followed it. It was customary international law, because everyone said, yes, this is also jus cogens and binding international law. And we follow it as a matter of custom.
Yes, and the ban on torture and so on. Yes, exactly.
Ja, und jetzt haben wir zum Beispiel.
Yes, and now, for example. Now that some people are saying that when a powerful state violates something, or a limited number of states violate something, for instance the prohibition on wars of aggression, or the ban on crimes against humanity or genocide, because so many civilians are dying in Gaza, no one has been convicted yet. But there are suspicions, even arrest warrants. That doesn't mean the rules no longer exist. Exactly. In one's personal life, if you witnessed a bank robbery, you wouldn't say, oh, someone's been shot. You also wouldn't say, oh dear, now the right to property and the right to life no longer exist. Those rights don't exist anymore. No, someone broke them. If you think something is no longer just cogens, you can only determine that scientifically by writing to all the governments in the world. And if an overwhelming majority says, no, we no longer see this as peremptory international law, we no longer consider ourselves bound by it. And with the UN Charter, it's a treaty too. If they all withdrew from the UN Charter, I haven't seen any withdrawal. No one has left voluntarily, so why should it be invalid? It's more likely that some people want to establish something different. Since the founding of the UN, we've always had a tension between the United Nations, where in principle, sovereign equality of states applies in the Kantian sense, even though the balance of power in the Security Council is somewhat uneven, so that the nuclear powers, at least the major ones, are always forced to talk to each other to prevent another world war. And, on the other hand, those who want to misuse the UN to turn it into a world government. Fortunately, the latter have always been in the minority, and attempts in that direction have repeatedly been blocked. Most recently, this was the case with the proposed empowerment of the UN regarding the international health regulations, which would have been a step toward a World Health Ministry under the WHO, something that, thankfully, could be prevented. Fortunately, these people have always remained in the minority.
Oder diese Schock,
or that shock, like when states are put into shock, like the UN Secretary General.
ja, 2024, als diese
Yes, in 2024, when this rubber stamp authorization was supposed to come through, Venezuela played a key role in softening the wording of the General Assembly resolution. Time and again, people stayed vigilant and prevented the UN from being used as a tool for a world government. And now, of course, there are once again people who want to move in that direction, toward a world government, pointing out grievances and saying the whole thing is being delegitimized, that something new must be created, or people who want to wage war because the UN stands in their way. So unbelievable. I'll say this, the people who are failing there are the ones sitting in some cushy position and not brave enough. What we need there are heroes who know the rules and say, I'll stand here and protect this with my life, and who won't be intimidated by anyone, not by scoundrels or devils. Sometimes people get distracted or are too afraid, but that doesn't make the law invalid. We just need to put braver and smarter people in those positions.
Exactly. And the fact remains that a majority of states simply do not participate in such matters. You don't get rid of international law by having individual states break it. You just end up breaking it. And what we need to figure out together over the next 50, 60, 100, 150 years is how to shape international law so that it can actually be enforced. But that's what we're working on. And I want to thank both of you very much for spending an hour explaining how this sanctions issue could be approached from a human rights perspective. For people who want to read more of your work, where should they go?
Leute, die mehr von euch lesen möchten, wo sollen die hingehen?
Wir haben zu dem, was wir heute gesagt haben, aktuell.
What we said today hasn't been published on a website yet. We have a blog where we've written articles. It's gone a bit quiet because we were also dealing with COVID, which took a lot of time. The blog is called Unser Politik Blog. We've also interviewed well-known figures there. If you want to see the quality of our work, though it was on a different topic, but it gives you an idea, on the website zavv.com, under the UN section, there's an English version of that parallel report. You can see that we wrote most of it ourselves, except for the parts where it's clear that someone else contributed. You can also find it at the UN, in the Committee for the UN Covenant on Economic, Social and Cultural Rights. That's what was submitted there. And that shows the quality of our engagement.
Please send me the links to those documents so I can add them to the description of this video. And then we'll stay in touch. And for people who want to get in touch with you, I can help with that too. We've already reached an hour now, so many, many heartfelt thanks for this overview, dear Sarah Luzia Hassel-Reusing and dear Volker Reusing.
Thank you very much for having us. It's an honor.
Ja.